Good morning. You're Zully Valencia.
Valencia.
And Ms. Valencia, you were previously in court and entered a plea of guilty to burglary of a habitation, a second-degree felony. This is 24 DCCR 1364. The agreement was for a cap of 7 years in prison. I've received the pre-sentence report and reviewed it. Has everyone had an opportunity to review it?
Yes, Sharon.
Yes, sir, we have.
Any additions or corrections?
I've reviewed the PSI with Zuli. I know that obviously her version, the court has questions about that, and so I would allow her to address that if she does wish to move forward in hopes of obviously us arguing for the probation.
So here's the thing. If you say you didn't do it, you don't get to say I didn't do it, but please give me probation, because then you're not accepting responsibility. So either you did it, what they charged you with, or you didn't. And doing it doesn't mean that you participated fully, and I'm sure Ms. Holmes has explained to you the law of parties in Texas and what that means. But if you say somebody took your car and you weren't even there and you had no idea of it, then that's what juries are for. Because you are about to take the chance, if we go forward, of me sending you to prison for 7 years. Me possibly giving you probation. But I can assure you that you're not going to get any kind of help from me if you get up here and say, well, I didn't really do it, but come on, give me probation. Does that make sense?
Yes, ma'am.
So tell me, if you want to go forward, tell me exactly what you did, what your part of this was.
I was aware of what my car was going to be used for. I didn't participate in the act, but I knew.
So you didn't drive your car?
No, I did not. I did not drive it at the scene where it happened.
Mr. Nichols, it
I
appears
don't know
that
if I'm explaining myself right.
I think what she was trying to say, Your Honor, she wasn't present at the scene of the burglary, but let them use her car and I guess drove them close by. Because we know she was pulled over driving that vehicle on the way.
I mean, there's cameras from Lieutenant Hudson's cameras that confirm that you were driving when you were stopped
Yes.
with the other guy seated in the
I
front
was
seat.
in town. I was in town when it happened, but I was not at the scene.
So, yeah.
So when did he get in your car?
When they brought it to the crime scene, but I was not at the crime scene. I was.
I'm very confused.
So she drove here to Groves. She drove into town. She was aware of what was going to happen.
You weren't aware of it. You drove in to be a part of, you knew. I mean, there's saying I'm aware of whatever. Y'all came into town with.
Can I rephrase myself?
You probably should real quick, because hang on.
I was
Also,
not at the crime scene.
hold on.
Yes, ma'am.
Because y'all came into town with radio jammers and fully ready with medical mask and face mask and all this stuff to come in from out of town to do what you did here in our town. And so you weren't just riding along and then they said, oh, by the way, sorry you came with us, we're gonna do this.
Okay, well, I drove because I'm the one that had the license, so in case we got pulled over.
Okay,
I was not at the scene.
so you brought them to do the
Yes, ma'am.
crime.
Yes, ma'am.
It's not that hard to say.
Yes, ma'am. I didn't know how to rephrase myself. I'm sorry.
All right, Ms. Holmes, go ahead with argument.
Yes, Sharon. She does not have an extensive criminal history. As you can see, there is one prior, looks like a theft of property, which she received 6 months state jail. And then there was a federal case as well back in 2020. Ms. Zuli is currently employed and working. She would like the opportunity to continue that with probation. She does care for family members as well, Your Honor, for a household. As indicated in the PSI, they do have her at a low risk level, which I believe is indicative that she would be successful on probation if given that opportunity. They've also stated in the PSI that they would like her to.
For this, even though she was stopped and is on video driving the morning of. So I think the 7 years is appropriate. I'll note for the court, the co-defendant got 10. At least one co-defendant got 10. I'm not sure on the others. But I think 7 years is appropriate, and given the instance of this case.
How'd y'all pick this person?
Sorry.
How did y'all pick this house, this person, to come and?
No, like I said, the only reason why I came here was because I had the license. So in case they got pulled over, they didn't have a way to prove their citizens. So I was just like the one that drove into town. I don't know about the.
And if I can, 2 of those individuals have fled the border. They were not legalized, so they probably will never be found. So there were 2 other individuals involved.
Right.
In which she has tried to get contact, so that's the reason why they were involved. She was the driver, but they have since fled the country. They're not coming back. That actually went into the house. There was only one that was caught that received the 10.
Mm-hmm.
So I think that's what she's trying to say is she was driving because they obviously did not have the credentials to do that, and we don't know where they are.
So do you know why y'all came to this house?
I have no idea. The only reason that I came into town was because I'm the one that had the license. So in case they got pulled over, they didn't have a way, to prove their legal
How many
status.
other times did they have you drive you to other places?
No, that was the only time I did it, and I regret it. It was crazy.
Your Honor, if I may, I had the co-defendant's case. The victim in this particular instance was a local business owner, owned a donut shop. They also owned a donut shop in, and forgive me if I'm off on the exact city, I think somewhere in Humble, or nearby in Humble. That business, their home in that city was also burglarized.
Right.
As well.
So right. Thank you,
I
Mr.
cannot show you I was not involved in any other situation that had to do with them. It was just a one-time thing.
How did you know these guys?
Well, basically one is my barber. The one that's doing time, he's my barber.
He's your brother? Barber.
Yes.
What about the other 2 that took off?
No, I never knew them.
So where do you live now?
I live in Houston, Texas. Yeah, Houston, Texas.
Do you work?
It's my
Where-
50 hours a week.
For what? For who?
It's integral. It's basically for the state. I get paid $25 an hour.
To do what? I'm sorry.
I don't know how to describe it. It's like solar panels. It's for the state.
Okay.
I have evidence as well.
You have what?
Evidence that I'm working there.
Okay.
Before that, I was working at a car wash, but they offered me more there.
So I don't disagree with Lieutenant Hudson or with Mr. Nichols because of what happened and the targeted way that this happened. It does appear that the guys were probably in charge of most of this. You made a really, really stupid decision.
Yeah. And I regret it.
Yeah. All right, what I'm inclined to do, because what you're charged with is a second-degree felony.
Yes,
So the range of punishment is up to 20 years if you went to jury, or all right, here's what I'm going to do. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. You're going to be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. So let me explain what that means and why that's good for you, but probably more so for me, and why I'm doing this. So a deferred probation means you don't have this conviction on your record. But what it also means is if you violate any condition of probation, you will be brought back into court, found guilty, so you have the felony conviction, and that cap of 7's gone. I have the full range of punishment between 2 years and up to 20 years. And certain cases, for whatever reason, the fact that this one, I remember it from Mr. Coleman's case, from the co-defendant, I'm likely to remember it. It's never good when I remember things, okay? And so I'm going to order also that you obviously have no contact or communication with any of the co-defendants. If they've fled the country, whatever, if they come back, if they try to contact you, you cannot have any contact with them. In fact, I'm ordering, if they contact you, that you contact your probation officer and law enforcement and let them know any information that you have about where they are. You will be, I want her on the medium-high caseload to start off with. It means you're going to be reporting more often, making sure you get off on the right track.
I work like an hour from my house, so I leave the house at 2:30 and come back home at 2:30 in the morning.
So talk to probation. I want you to work, okay? And so you need to get them documentation of your schedule, because there will be a curfew except for employment purposes. You'll be required to report in Harris County, but you're also going to be required to report by mail or online here. So you kind of have double duty. You've got to do it all. If you don't report by mail or online here, it's a violation. If you don't go in person there, it's a violation. If you don't give them proof of where you are when you're supposed to be, it's a violation. If you test positive for any drugs, whatever it is, you're going to be on a high caseload so that I know, at least for some time, that you're doing exactly what you're supposed to be doing. And if you don't, you will be right back in here. Do you understand? All right, I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she'll call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am.
Thank you.
All right, sir, you're Jaron Crane. And Mr. Crane, you're charged in cause number 23 DCCR 1082 with evading arrest or detention with the use of a vehicle. In cause number 23 DCCR 1406 and 23 DCCR 2233 with aggravated robbery. And what is the announcement?
Judge, we've gotten a new offer, gotten an offer on Mr. Crane, and I've given it to him and talked to him about it. I was gonna ask for a short reset, maybe like 2 weeks, just so we can talk to his parents. And I think that it'll be resolved at that moment. It won't be.
Okay. Any issue?
No, Judge, that is fine with me. I just want the court to know it's no longer any type of a probation offer that the state is extending based on the nature of where we got last week with Mr. Crane.
Right.
For some reason, that attitude changes. We'll approach the court with that, but I appreciate you letting us hold on that. It is my intention, I want Mr. Crane to know for me, it's my intention to go on his case to trial first and ask that any sentences that can run consecutively, run consecutively.
So, Mr. Crane, I'm going to reset your case a couple of weeks.
Yes, ma'am.
We're done playing games, all right? So, if you were, whatever all happened, if you've changed your mind, it doesn't matter to me. I don't care. But we're not putting your case off for someone else's case anymore. Your case is going to go forward. You have 2 weeks to make up your mind on if you want to accept this plea agreement or not. If you don't, then we'll get your cases set for trial very quickly, and your case will go to trial. And after that, I'm not accepting plea agreements and all of that. So this is where you need to talk to your attorney, family, whatever you need to do. When you come back, I want to know either we're taking a deal that day or you're going to trial. Doesn't matter to me which way, but we're not putting it off anymore. We're not going to say we're going to do this or that and then get your case put off. It's going forward, okay?
And Judge, we can be prepared very quickly. I've already prepared all witnesses in lieu of the other trial.
Okay, thank you. All right, you're free to go. We'll see you in a couple of weeks.
Thank you, Judge.
Good morning, ma'am. Is it Farrell or Farrell?
Fair.
And will your client waive the formal reading of the indictment?
She does, Judge.
Ms. Farrell, in cause number 23, DCCR 1088, you're charged with, my computer's slowing down, sorry. You're charged with the state jail felony offense of credit or debit card abuse from August 4th of 2021. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would not be a fine. There would be restitution paid in the amount of $15,516, and you would be required to follow all of the other rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Farrell's not competent?
No.
And what about history or waiving the pre-sentence report, since we have that restitution
The
amount?
state's okay with waiving the PSI. I only show 2 misdemeanor convictions, one from a theft from over 20 years ago, another DWI from about a little more than 10 years ago.
All right, so Ms. Farrell, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and however, I'm going to follow the agreement and defer all proceedings. You are placed on probation for 5 years. You're ordered to pay the restitution in the amount of $15,516 and to follow all of the rules and requirements of probation. If you do that, then this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you could be brought back into court, you could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? $15,000 is a lot of money to pay back. 5 years might seem like a while, but it's not. It's very important that you start making payments on that immediately. Even if it's a little bit every month, then it will add up, because what can happen is, let's say you do 4.5 years of probation correctly in every way except paying that restitution, and I make a finding at the end of that probation that you could have paid, then your probation can be revoked and you could still go to the state jail prison for 2 years. Do you understand? It's very important that this gets paid back. I want it to be a priority. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. She's at that desk right there, so watch for her to call you up. Good luck to you, ma'am.
Thank you, Judge.
Good morning, you're Paul McCorvey?
Yes, ma'am.
And this is 24 DCCR 1914. Mr. McCorvey is charged with theft of property, and what is the announcement?
Judge, this was the one that it's taken a while to get some things from a probate court, which we did by the last setting.
Right?
It was reset because we was trying to confirm restitution amount with the complainant. She won't talk with us. I think the issue is Mr. Hoffmeyer is going to try to get with the investigator, see if they can confirm an amount. Because basically the restitution was going to resolve
Right.
Correct, Judge, and the notes, according to Mr. Hoffbauer, are that based on that probate order, just a very short conversation with the complainant. Now, we have that transcript should get us to a figure that should be able to resolve.
Okay.
And I can make sure that.
If you would, because that's where I thought we were last time. And so if you'll get with him and make sure Mr. Hoffpower gets on that quickly so that we don't have another reset based on that, please,
I will,
ma'am.
Judge, I'll bring
Thank
her
you.
in.
All right, stay in touch with Mr. Lewis and he'll let you know when you need to be back. Good morning, you're Ashley Sanders. This is 24 DCCR 1650. We were waiting on audit. Where are we?
Judge, I'm happy to announce, thank you for the court being so lenient with us and resending this a few times. Mr. Wimberly is actually here this morning with his client, my complainant. They did send me some documentation just right before docket. He's also indicated that his office is this week making notebooks for Mr. Kelly and myself and having everything scanned in. If we may just have one final, now that we have all that information, hopefully we can I can sit down with them, then Mr. Kelly and I can sit down and discuss it and see where we are, and we'll be ready to finally announce next time. But I did want to confirm we do have all that documentation, or
Okay.
it should be to me this week.
All right. Thank you, Mr. Wimberly. All right, so what I'm going to do,
And if you want to go ahead and put it on the trial docket, Judge,
no.
I certainly would understand.
Yeah, no, I just want to, let's see.
My only concern when I hear notebook is.
That's what I'm
kinda
thinking as
notebook are
well.
we talking about?
Yes, sir.
It'll be about that thick,
Okay.
with all the text.
So why don't we do this? When we come back next time, I want it all done and I want an answer. And so what I'm going to do is reset it to the 1st of January. That should be about a 60-day, little more than that. I want everything hopefully turned over this week. That gives you an opportunity. So unless there's something else that comes up, I want it all gone through in an announcement at the next court date.
Yes, ma'am.
Okay? All right, you're free to go. Thank you, sir.
Thank you.
Thank you, Mr. Kelly. All right, ma'am, you're Brianna Clanan. And will your client waive the formal reading of the indictment?
She will.
Ms. Clanan, in cause number 25, DCCR 0446, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from March 8th of 2025, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $250 fine.
I'll explain my scribbles, Your Honor.
Oh, that's CCCR. There would be
Yes,
a
there's
dismissal
miscommunication.
in cause number 25 CCCR 1119. And this will run concurrently with 25 CCCR
1053.
1053. Is that your understanding?
There should be another misdemeanor.
It was refused.
Oh, it's refused.
And what are those
The
cases?
dismissed one is resisting arrest, and they're all connected to this, Your Honor.
Mm-hmm.
The dismissal is a resisting arrest. The case to be pled is a DWI.
Okay.
All out of the same criminal episode.
Let me look at something real quick. Oh goodness, I can't see that. If I test you this morning, will you be clean?
Be honest.
Have a seat in the jury box. Good morning, are you Ryan Hodge?
Yes, ma'am.
And Mr. Hodge is charged in cause number 24, DCCR 1167. With the third-degree felony offense of evading arrest or detention with the use of a vehicle. The indictment alleges a prior burglary from 2015. And then also felony of bribing an officer in 2018 and possession of a firearm by a felon in 2018. We had reset that as well. some other stuff as well.
Those are out of state.
Yep. So what that means, though, is for punishment purposes, if Mr. Hodge, if you're found guilty by a jury, you would be considered a habitual offender, which means your minimum punishment, if you go to trial and are found guilty, is 25 years in prison, up to 99 years or life in prison. Do you understand? And we reset this case for you guys to watch the video, and have you had an opportunity to review the video in this case?
I've seen it prior, like, but,
You've seen the video?
I think
Yeah,
he's
I've
seen
seen
it with his
Okay,
previous.
so you've
attorney.
seen the video, and have you talked to Mr. Kimler about it? Answer out loud.
do what, man?
You've
Have
seen,
you
we've talked about the video.
Yeah, we've talked about it, yes, ma'am.
Okay, and I want to make sure, so I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count one only, which is just the offense of evading arrest or detention, not those prior offenses, for a cap of 10 years, which means you would leave your punishment up to me. I can give you 10 years, I can give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand what your possible consequences are and what your options are. And do you understand all of that? And so I'm also making the notation here on that plea bargain rejection that I've admonished you as to what the minimum will be if you're found guilty, which is 25 years in prison. You understand? And you want to reject that and have your case set for trial.
Yes, ma'am. I didn't run it, I was just speeding and driving.
He's maintained his innocence.
All right. Then I do want to make sure you understand that after today, I will not accept a plea agreement. I'll get your case set on the trial docket. There won't be a plea. We'll let a jury decide, okay?
So, for any reason, we can look into it further, the facts and the evidence. That I
Well, that's what a jury's for. And so your attorney has discussed the case with the assistant district attorney. Their position is that it's an evading and they think they can prove that, and that's what we're going to go to trial, okay? That's what a jury's for. All right? Okay, and she'll waive the formal reading of the indictment in each.
Yeah, sure.
So, Ms. Randall, in clause number 25, DCCR 0246, you're charged with a state jail felony offense of theft of property with previous convictions. And that one's from November 21st of 2024. The indictment alleges you were previously convicted of theft April 4th of 1984 and April 11th of 1985, both misdemeanors, which would get us to this state jail felony level. It further alleges that you were convicted of a non-state jail felony offense of theft April 10th of 1989, and then again November 12th of 1991, and then after that was final, October 10th of 1994. And how do you plead to that charge? And are those prior offenses true? Or prior convictions true, excuse me. Are you entering your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? All right, give me just a second to get this pulled up so I can make that notation. I think that was 1 through 5.
Five or six, depending on how we want to look at it.
Find sufficient evidence to find you guilty in each of your cases. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information on you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Vasquez, and he will present it to me on your behalf when we come back. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
Thank you, Judge.
Yes, sir. Good morning, you're Shay Morgan. And Ms. Morgan, in cause number 24, DCCR 2102, is charged with theft of property. And what is the announcement?
Judge, we're going to ask for a regular resetting. Ms. Malfino and I are discussing a potential resolution. It's also been given some documents from my client that I think will help inform that process. And so,
Any issues?
No, Judge, it looks like we do at least for purposes of this announcement, have a restitution figure, so we wouldn't need time to develop that. So
Okay.
We can just share that information with the council.
Okay.
Hopefully we can
And the
resolve
case
this.
looks old, but I realize that you were just hired in the end of July, so we'll just do a normal reset. And then, Ms. Morgan, make sure you stay in touch with Mr. Gert so you guys can go over everything. We'll try to get an announcement at the next court date. All right, you're free to go. Thank you.
Jeff. Have a good week.
Thank you. You too.
I guess I'll see you tomorrow.